Today we're going to pick up on statutes of discrimination. We talked a little about it last time, but let's pick up pretty close to where we left off. Well, we did list the various statutes that are most important in this area. One, the Equal Pay Act of 1963, and then the Equal Employment Opportunity Act, maybe the most important act, which is part of the Civil Rights Act of 1964. And then the Age Discrimination and Employment Act in 1967, and then the Americans with Disability Act of 1990, and of course we also mentioned that there are state laws that both predate and were passed after the 64 Federal Act. There were state acts passed after and before it. New York is one of the better ones, providing lots of protection. Anyway, so what was the Equal Pay Act? Well, it prohibited gender, salary, and wage discrimination if the job content is the same. In other words, it can't be a comparable worth job. So it does not require equal pay if the jobs are considered to be of comparable worth. That's where you maybe have one job's a secretary and the other job's a dispatcher in a trucking company, and the man working in the trucking company is making more money than the secretary, and their jobs are studied by psychiatrists, and the psychiatrist says they're both just as difficult and require comparable skills to perform successfully, and just as difficult, and therefore should be paid the same. But this argument was rejected by Judge Kennedy before he became Justice Kennedy on the Supreme Court. He actually decided in the Ninth Circuit that what people get paid is determined by the market, and so that became really the basis of rejecting claims that, well, somebody should be paid the same because their job is of comparable worth. So we don't hear much about that anymore. And anyway, does not prohibit, now the Equal Pay Act does not prohibit also pay differences based on seniority. So somebody who's being paid more because he's been there longer, or on merit. His job requires certain skills and that are extremely, and he's very meritorious, very good at it. It doesn't provide prohibit pay differences based on productivity or any other factor other than gender. As a matter of fact, all statutes are that way. These four items are mentioned in almost all other cases. If it's not a factor related to the specific discrimination, it's not going to be affected by the statute then. So that's the Equal Pay Act. Title VII prohibits discrimination based on race, color, ethnic origin, religion, sex. Doesn't say anything about age. That has to come later. Doesn't say anything about sexual orientation. Matter of fact, sex itself was largely in dispute in many ways. As we'll see, sexual harassment was in dispute. So it doesn't say anything about it in the act. It was passed very quickly. And so it was really a case where sex was added at the last minute, and so didn't get much statement of what it was about. Anyway, the EEOC, before filing suit, alleged the victim must first file a claim with this agency. But so the statute sets it up that before you can go and file suit in the court, you have to take it to this administrative agency called the Equal Employment Opportunity Commission, the EEOC. And they have the right to sit on it for about 6 months, and then they need to, unless there are reasons, they need to issue either a right to sue letter, or they need to resolve the case in some fashion. So and they may decide, if they issue a right to sue letter, you can then proceed to court. That doesn't mean you won. That just simply means that you've gotten the right to go ahead to go through court. If they can, they'll try to resolve it, oftentimes trying to mediate between the parties. But the EEOC will investigate and attempt to get a voluntary settlement of the case, typically is what they do. EEOC can, but usually does not file suit on behalf of the alleged victim. It can do so, but it usually picks those cases by whether or not an issue needs to be resolved, they think, and so they want to have a court resolve it, so they'll maybe bring the case. If it cannot settle and does not file, it will issue a right to sue letter to the victim. And like I said, then he can go ahead and sue. And disparate impact discrimination. Sometimes what appears to be a neutral means of screening applicants can result in a disproportionate number of minorities not being hired or not being promoted. If the defendant cannot rebut a charge of discrimination for disparate impact discrimination, and he has to do this by showing a strong connection between the required neutral means that might be a test, might be other non-essential requirement for a job, some sort of thing that you have to do to get the job. So for instance, in California, the LA police used to have a requirement that anybody who wanted to become an LA police officer had to pick up, I think it was a 130-pound bag of sand and carry it like 200 yards, you know, within a certain time. And now this would be a task for many people. Even fairly strong fellows would maybe have difficulty doing this. The idea with the LA police was they wanted their police officers to be rather intimidating, so they could resolve things without maybe gunplay. That was what they said. But the result was that, of course, that women were disproportionately affected. So very few women could make it onto the police force because of this requirement. Women generally do not have as much upper body strength as men, and so, you know, they basically didn't have, I think, any women on their police force. And so women brought a lawsuit and had it declared illegal. That's the kind of thing I'm talking about. Another one is the requirement of IQ tests. An IQ test is not really a test that tells you whether somebody's going to be good at any specific job. It was supposedly a test of general intelligence, and now the psychiatrists tell us it's not really that. What it is good at is predicting who can do well in school, and that's what it was originally developed for. It shows if you can manipulate words and numbers very well, but not much else. And so generally speaking, I can't think of a job that it would actually help predict success in. It doesn't show leadership, doesn't show artistic ability, doesn't show proficiency in solving problems. So it's generally not going to be what you're going to use to pick managers or some other thing, which some people tried to use it and said they were using it to pick the best managers. It doesn't really show the kind of qualities that you want in a manager. A manager has to be empathetic, he has to be a leader, he has to know how to get along with people. A lot of people with high IQs don't necessarily know how to get along with people. You know, it's a separate kind of thing, separate kind of intelligence, but I don't know if there is a test for it. I know that there are various tests that are used for various things. Police sometimes take stress tests to see whether they can handle being in stress. I mean, that maybe makes sense for a police to have to deal with anxiety and stress on the job, because he is oftentimes put in stressful situations. So, you have to show the connection between the job and the test or the means used to separate out people. And it has to be something that's not going to disproportionately affect minorities. So if the defendant cannot rebut by showing a strong connection between educational requirement, test, or other non-essential requirements for a job and improved performance, then the plaintiff will not have to prove intent. So remember, you should remember that actually, as we'll see, I think we'll mention it later on, there's a prima facie case. In a prima facie case, all you need to do is allege discrimination, and then they have to rebut that with proof that they're not discriminating. So this is what this is talking about. Okay, so a woman alleges that she's being discriminated because of the use of this test of carrying this weight, and then the police would have to show some justification of why it's being used. It's not essential, certainly, but is there any sort of benefit for it? Yeah, you can argue, well, it's useful for police to be big, scary guys, but then again, a woman can handle a lot of jobs for police just as well, and maybe better in some cases. Okay, now harassment. It can be based on any factors. A lot of people think of sexual harassment, but it's certainly, although maybe the most known, it's certainly not the only kind of harassment. In fact, it was preceded by race, color, ethnicity harassment, and even religious harassment. And nowadays you also hear about not just sexual harassment in the sense of somebody being raped, but also gender harassment and marriage harassment and LGBTQ harassment There's also harassment that takes place in union, but that's not covered by Title VII. So we're talking about the kind of harassment covered in Title VII. And one of the things that escapes people's ideal is the idea that the harassment may result and may involve a hostile work environment that causes any of the following. Constructive discharge. That's where somebody hates so much working at their job that they can't go in anymore. You know, it causes so much emotional distress. So they leave their job, but you know, they're going to sue and they're going to be able to claim money for the time that they're not working because of the harassment, if they can make that case out for the harassment. So we'll see how that's done. Decreased job satisfaction can come because of a hostile working environment, and we'll talk about some cases involving that. Emotional harm obviously will arise because of anxiety of the harassment, or other damages to the victim. There'd be physical damages. Did somebody threaten him? You know, there may be other kinds of damages. So anyway, employers have an affirmative duty to protect the harassed employee from others and take remedial action. So it's up to the employer to do something about it. And you know, you can't ask the victim to ignore it. He can't, for instance, move the victim to a different job. He's got to deal with the fact that he has to do something about the harasser. So oftentimes it takes the form of you know, maybe punishing the harasser so he'll stop doing it and won't do it again to anybody else. That's the way it is. Or you might fire the guy. Okay, that's sort of like a permanent thing. If he's not going to reform himself, you're going to wind up firing him maybe. You can try other things, but you know, it's got to be something that's not going to be a burden to the victim. So they have an affirmative duty. That means they must positively do something about it. And when they knew or should have known of the harassment, they need to take action. So some cases they need to be told. They wouldn't know about it otherwise. So there is a requirement under the guidelines for the victim to alert them to the harassment. And sometimes that's necessary, sometimes it's not. If it's the president of the firm that's doing harassment, it's not. You know, they should know. And so, depending upon who the harasser is, you may or may not need to notify. So if it's the bus boy, the boy who delivers people's mail in the morning, is some low-level employee, he might be harassing a higher-level employee themselves. And you know, this has got to be taken care of, though, and that person has to be protected. You can't have your employees being harassed by anybody, and that includes your customers. So you can't like curry favor with your customers by allowing them to harass your employees. So you have an affirmative duty to do something about it. And let's see. Let's talk about some cases. I call this the Mayflower Hotel case. Now, it's a famous hotel in Washington, D.C., and for the bicentennial, 200 years since the signing of the Constitution in the 70s, this waitress was forced to wear a rather revealing uniform. It was supposed to be part of the bicentennial theme. However, I'm pretty sure that they wouldn't have had this uniform back in 1776, 1789 either. You know. And so she was forced to wear this very revealing uniform, and she was a woman with rather large proportions in areas that cause interest. Okay, and she, when she was shown the uniform and told that she would have to wear it, she immediately told them that, well, she couldn't wear anything like that because she knew from experience that it would cause a lot of untoward comments, unwanted comments that she didn't want to hear. It might cause a stir, and that she didn't want to be involved with anything like that. She was not that kind of a person that she would like that kind of thing and would be very much distressed by it. She's a married woman and very respectful, and she said, I can't wear that uniform. So she asked to, you know, if she could stay with the uniform they had previously, and they said no. And she asked if she could modify this uniform so it wouldn't be quite so revealing. They said no. They insisted, well, you have to be consistent with our theme, and we've had this design, paid a lot of money to get this design, and you have to wear it. Now, in truth, it's probably no more revealing than what other waitresses at some restaurants would be doing. You know, so, and some waitresses do that. Now, if you go to and take a job at one of those restaurants that have very revealing uniforms, then, you know, you're moving to it, and therefore you can't complain. But in this case, She had a job with the motel restaurant that was, you know, had a very modest uniform, very typical, say something you might have seen at, say, Bob Evans, very just sort of homespun, probably more appropriate for this bicentennial actually. But no, they decided they needed to do a new one, and they forced her to wear this uniform. She wore it, and she got the comments, and she told them she was getting these comments, and they said, well, you just have to deal with that. And she said, no, I don't, and she left and claimed constructive discharge. Constructive discharge, like we said earlier, is where things become so uncomfortable that you can't stand working there anymore. And as a result of the lawsuit, she was awarded back pay and could claim reinstatement. Okay, so there you go. This is a matter of force. They could have gotten around it by simply telling her that she could modify a uniform, or maybe even helping her, maybe them modify it in a way. They should have been willing to do that. And you know, but you got to protect your employees. I had a similar case involving a computer sales lady, and she was showing some Japanese customers who come over from Japan these computers, and they were all the time making improper suggestions and statements to her, and she didn't like it, and so she complained, and her boss said, well, you know, these are our customers, you've got to treat them well. You can't do that. You can't be putting your employees in that spot to make money. Anyway, the job doesn't depend on that. Anyway, female engineer harassment occurred in another case. There was this female engineer, a Regent graduate with very high grades, and she was put on a project with some other men in a very well-known, I think it was General Electric, but and she was working on this engineering project, developing maybe a product or something, I suppose. Anyway, so these engineers were working on the project, and when they were told that they were going to be joined by a new female engineer, they immediately complained that she was going to be a drag, that she would just simply get in the way, that, you know, why did they have to carry her, basically. And, you know, so they were very chauvinistic and very male-oriented, and believed that women couldn't do engineering. If she got a degree, it must have been something funny about getting a degree, I suppose, is what they thought. Even though she had had high grades and had good recommendations from her teachers, they were not going to cooperate. And they made it clear that they didn't want her. But the boss said no, they had to have her. The company wanted to show that it was accepting of female employees. They didn't have a lot of female employees. Matter of fact, no engineering firm at that time had, because there had not been a lot of women who had graduated from engineering school at that time. The discrimination of women in that field reflected the fact that people generally did think that women couldn't do this kind of job. And so women were not encouraged to do it, and were oftentimes told, well, you shouldn't go into that kind of job. And so, you know, they weren't given a chance. Nowadays, there's actually women working in the field and doing well. And there had been women working in other countries before this that had done well and proven themselves to be very competent and very good engineers, just as good as the men. Anyway, they constantly what happened when she went to the group is they constantly made crude jokes involving the female body, sexual situations, and fat jokes. Why fat jokes? Well, she just happened to be a short woman who was 300 pounds. So she's a little round woman engineer. That's what she was. She couldn't have that right. One day when she came into work, someone placed a crude drawing on her desk of a fat woman with a stick figure man stuck up her wazoo. Constructive discharge? Yes. She was very uncomfortable, and she quit. And didn't quit the job. That is, she quit working there. She just walked out and said, and then she sued them and got damages awarded for emotional distress and back pay for the time she left until she accepted reinstatement. You know, and they had to give her certain concessions for her to do that. Anyway, that's third case. This is a secretary, ordinary secretary, being harassed, working for the boss, and she's dealing with the salesperson. It's an insurance firm. So this star salesman, was harassing her. She told the boss and she told the personnel director, and they said, well, you know, he is our best seller, and we need him. We want to keep him. And so they suggested that they would give her a transfer to another office in the same insurance firm, but the other office was 300 miles away, and she didn't want to leave her family, and her children were in school, and they would have to relocate. She didn't want to do all that, and she said, why do I have to move? I've done nothing wrong. And she's right, she doesn't have to move. They have to find some other solution to the problem. So they were found to be actually wrong, and basically constructive discharge and back pay, and she settled, I guess, for a lot of money. Rather than come back to work, a lot of times what people will do is settle for some sum of money rather than come back to work. So you'll get the court can order that she be reinstated in and brought back into the firm, and that the employees be instructed to treat her differently. But she didn't want that. She didn't want to go back for them. And so instead, she and her lawyer negotiate some sort of settlement agreement where she got a sum of money, and they didn't have to take her back. Oftentimes, the companies don't want to take them back, and they'll want to maintain that they won the case, even though they'll tell everybody, "Oh, we won. You see, she never came back." Yeah, because you paid her off. And that's a very typical thing. Politicians do that too, right? When they're being sued for things, as we know. Bostock versus Clayton County. This is a new case. Now, those other ones were old cases that I had actually researched back when I wrote my paper on sexual harassment. So I knew those cases, and I used them to show how various sexual harassment can be. And it's not always simply propositioning. Sometimes it's that, but oftentimes, like in the Kiriatsi case, that's the female engineer, I believe, she wasn't being sought after for any sort of sexual reasons other than just for their own humor, I suppose, or just simply trying actually to drive her out of the job. So it was more a matter of power. And Bostock, I think, actually is about that too. In early 2013, Bostock joined a gay softball league and promoted it at work for volunteerism, wanted people to volunteer to join his baseball club. And his employer did an audit of the funds managed by Bostock, so he was managing funds for a county, and they fired him for conduct unbecoming a county employee when they found some misspent funds, which were not unusual, I think, and it wasn't a big deal. It was not something that was very large. And his employer used the claim of misspent funds as a pretext for firing him. So what's a pretext? A pretext is a reason that's not the real reason, and it's something minor. So let's say somebody comes in and he's 3 minutes late. Do you fire him? Typically not, In order to be able to fire him, what's going to happen if you did fire him? Probably you're going to have a lawsuit, and what you're going to be asked is to show your records on, and let's see whether you fired anybody else for being 3 minutes late, or or you fired anybody for being late for any amount of time. I knew when I worked, we had a secretary, and she was gone for 3 days. She showed up, and we kept her. She wasn't fired till 2 years later. I don't know, but boss told me to keep a file on her, and that we would fire her eventually. That he would fire her eventually, but he needed to have enough. It was public employment. I was working for the state of Kentucky, and she was a state employee, and so apparently it's harder to get rid of them because they have due process rights. And so I left. When I left there, she was still working there, but there was a file building up on her, and she was doing other things too, like using the phone improperly and making long distance calls and charging it to the department. So we had this file on her. And she should have known we were doing that. I think I told her that you need to stop doing these things. But apparently she continued. His employers used the claim of misspent funds as a pretext for firing him. The district court dismissed the case based on the 11th Circuit precedent. Title VII does not include protection against in cases of sexual orientation. So they dismissed it on account of this case being a case of dismissal based on sexual orientation. If in fact we accept his claim true that he's being dismissed for this reason, it's not, it's not valid because we will not recognize that. So, interestingly enough, back in the early 70s, when I was in law school, There was even a reluctance for some federal courts to accept any sort of sexual harassment claim in any case. And the reason at that time was they said, well, you can't show us in a historical record that anywhere where it talks about sexual harassment. Nowhere in the statute does it mention sexual harassment or anything about sexual harassment, so we don't think it was meant to be included in the act. We think it's just simply sexual harassment was just merely holding a woman's sex against her, holding her gender against her. So the equivalent, for them it was the equivalent only of gender harassment. You know, you know, on the other hand, race harassment was present, and you know, and there were cases of race harassment under Title VII, which is the same title as sex harassment applies to, and there was actually ethnic harassment and color harassment and religion harassment. Why not sex? They just refused to read that into the statute, and so eventually the Congress did write it in. But there were many courts that had accepted, and the Supreme Court had accepted before. Some lower courts, various circuits, maybe didn't recognize it for a long time, but eventually it was all recognized. His employer used the claim of, you know, anyway, Title VII does not include protection against cases of sexual orientation. This case was sent up and appealed, and it got up to the Supreme Court. Judge Gorsuch, in a 6-3 decision, so it wasn't really all that close, the court held that Title VII protections cover sexual orientation and gender identity. So this is the first case. The Supreme Court recognized sexual orientation, and after that, all the other courts had to follow. Those who adopted the Civil Rights Act might not have anticipated, here's what he says, this is a quote from him directly, what he says in his opinions. Those who adopted the Civil Rights Act might not have anticipated their work would lead to this particular result in this kind of case. But the limits of the drafters' imagination supply no reason to ignore the law's demands. Only the written word is the law, and all persons are entitled to its benefits. So he's a textualist, right? Or is he? Let's take a look at the dissents. So he broke with the usual conservative bloc, and they dissented, except for Roberts. Roberts joined in his opinion. Anyway, so what is dissent? Okay, this is Alito's dissent. Judge Alito, joined by Thomas, dissents. He accuses Gorsuch of engaging in a deception. There is only one word for what, this is a quote from Alito, there is only one word for what the court has done today, legislation, he says. A more brazen abuse of our authority to interpret statutes is hard to recall, what he says. The court tries to convince readers that it is merely enforcing the terms of the statute, but that is preposterous. So he's saying that it's not textualism, you know, and basically he's saying he's reading too much into their words. You know, they never mentioned sexual orientation. Well, they never mentioned sexual harassment either. But it's obvious that a lot of courts found that there was sexual harassment way before the Supreme Court decided it was there, and the Supreme Court eventually found it. And then Congress itself said, yeah, that's what we want. And so that situation can be remedied by the legislature, but it may take a long time. It may not ever happen even, in some cases. What is workplace harassment anyway? Workplace harassment is overbearing supervision, bullying, constant criticism, and blocking promotions are all considered workplace harassment. Wide-ranging types of harassment involve emotional and physical abuse. So sometimes it does result in physical abuse, and therefore physical harm. Workplace harassment blocks successful advancement in their careers, often gets in the way of a victim's self-fulfillment. So if it's going to be creating a hostile work environment, the employee is not going to be realizing her satisfaction, not going to be happy in the job, and it's not maybe going to be able to fulfill her life goals because, you know, she's just no longer enjoying doing the work that she maybe studied for, and that's going to be an awful thing for anybody. Anyway, Romer versus Evans. The Supreme Court held 6-3 that a state constitutional amendment in Colorado preventing the protected status based upon homosexuality or bisexuality did not satisfy the Equal Protection Clause. So the Equal Protection Clause, usually we apply a tiered approach to this. Judge Kennedy states that its sheer breadth is so discontinuous, this is a quote from him, with the reasons offered for it that the amendment seems inexplicable by anything but animus towards the class that it affects. So basically, the Colorado, in certain of its cities, Boulder and other cities, major cities in Colorado, the big cities in Colorado, passed statutes to protect sexual orientation, and this was before the state did it. The state eventually did do it, but before the state did it, the Supreme Court jumped in. The Supreme Court jumped in and said that it was illegal, and so Justice Kennedy says it's sheer breadth. No, the Supreme Court didn't jump in immediately. It was the state court declared it to be okay, or declared the amendment preventing these cities from adopting this statute. Judge Kennedy said its sheer breadth of the Colorado state statute was too broad, and that it showed an animus against. It showed animosity towards LGBTQGT, whatever. It lacks a rational relationship to legitimate state interests. The court stated reasoning did not use the traditional tiered analysis. So there's a tiered analysis where you judge things on strict scrutiny if it's involving oftentimes discrimination against a discrete minority that has in the past suffered from discrimination, which would then be applied. So that would maybe arguably be within that tier. Basically, there's been a lot of restriction on that tier, and so at first there was only two tiers: strict scrutiny and rational basis scrutiny. And it was said about strict scrutiny that strict scrutiny was the same as strict liability. It was just automatic. You were going to lose if you were subject to strict scrutiny. It was just generally applied to race cases originally, and then it was not applied to even gender discrimination or harassment against women or anything like that. It wasn't applied because it was they said that they didn't have the same history of discrimination, that they had maybe not suffered as much as maybe the race, and it was decided that they would have intermediate scrutiny, something less than strict scrutiny, but something more than rational basis. So with strict scrutiny, you have to show a compelling interest being frustrated, and that there's a narrow means of dealing with it. So the court, if it's too broad, can't do it. And anyway, it said in this case, he said the discrimination lacks a rational relationship to legitimate state interests. So that doesn't fit. So it has to be a very narrow kind of thing for state interests. The court stated that it did not use traditional tiered analysis and was criticized by the conservatives for that. Although some conservatives criticized the tiered analysis anyway. Romer versus Evans. Yeah, that's the one I just read, I think. Yeah. Okay. Now we go to equal protection and justification, strict scrutiny and minimal scrutiny. In cases involving a suspect classification, that would be race discrimination against blacks, would be gender discrimination, I think. Against women, I think it should be, okay. Or a right that's deemed fundamental, like the right of free speech, one that's guaranteed by the Constitution explicitly. They'll apply justice, strict scrutiny. So justice only where justified, such a statute is justified only where there's a compelling interest. So, so that's very rare. Strict strict scrutiny is basically you're going to lose. A narrowly tailored, or at least to the least intrusive means. Okay, so that's what strict scrutiny implies. Then there are minimal scrutiny. In cases where the property or other economic issues are involved, then the statute will be justified if the state has a rational interest in the outcome. So it just has to have a good reason. Any reason will do. It doesn't have to be a strong reason even. And it has to be tailored to accomplish the stated goal. So it has to be reasonably thought that it can accomplish the goal. And so that gives actually a very wide latitude to the state in passing statutes. But like I said, that's used in cases that are maybe not involving a class that has been subject to historic discrimination, like women and race and the LGBTQT. Okay, mid-level scrutiny, substantial government interest, well tailored to accomplish the stated goal. That's what we use in regard to women. And you know, those things are still on the book. I don't know how well they're being followed, but they're still there, even though they've been criticized a lot. Justice Thurgood Marshall thought that there should not be these tiers, that they ought to be maybe some sort of sliding scale, you know, and that each case should be kind of individually looked at, you know, and others have criticized the whole setup. Some people said, oh, we just need the old rational basis. That's what we'd used for before the civil rights movement actually began to take effect. That's what we used before the 50s. Affirmative action, Civil Rights Act 1964, purpose to eliminate barriers which in the past favored white employees over minorities and not to impose a racial balance. It was not to impose a racial balance, but simply to eliminate a manifest racial imbalance. So it's not like you have to reach exactly the balance. That's not the purpose of it, but it is supposed to eliminate imbalance. And it also is, the emphasis is on removing barriers that in the past have created this imbalance in the workforce. You know, and so typically what needed to be done was you had to prove this racial imbalance to get an affirmative action order. And so to this day, both income inequality and unequal rates of unemployed minorities remain a fact. So basically one could say that we've had this thing for years, and it's had some effect, but it's certainly not true that we have actually done away with our problem in terms of racial imbalance. Income inequality and unequal rates of unemployment are still there. Okay, so basically, what's done with affirmative action? Most plans then and now, I think, are basically usually voluntary plans. That is, they're not usually ordered by a court. But a court may order a plan where proof shows, you know, so if you're a group that wants to promote black employment or women's employment, you might bring a case, and what you have to do is show that a suspect class, women or minorities, has in the past been underrepresented at a workplace. So in the South, you could find all kinds of factories and other jobs where, you know, blacks had been largely excluded from the better paying jobs, if not completely excluded. You know, and so you might find a factory and all the assembly line workers were white, but there were some black workers who were working in maintenance, cleaning up, you know, pushing a broom and cleaning up, you know, removing the grease and doing all the dirty work associated with that. So you would have, you know, sort of the segregation in jobs. You'd find, you know, that in a restaurant, the people who were dealing with people, the waitresses and bartenders were white, but in the back there might well be a lot of blacks who were working, cooking in the hot kitchen, or, you know, cleaning up the trash and washing the dishes, jobs that aren't really that appealing to most people. And so a secular class in the past has been underrepresented in this workplace, in some part of it at least. And the plan establishes goals and timetables. So you basically go in and you do a statistical analysis, and, you know, so for instance, Birmingham, Alabama is more than 50% black. I think it might be 60 or 80% black. It's a huge number of blacks in Birmingham, Alabama at that time. 70%, well, it was anyway. And then you go into a factory in Birmingham, and in the factory, the assembly jobs were largely, like I said, exclusively white, and there were a few blacks. Certainly nothing like 70% of the people working there were actually black. It was mostly white workers, especially in the better paying jobs and the more sought after jobs. So some jobs are sought after for strange reasons. So when I worked in factories, one job that was highly sought after was running the tow truck that was moving the stuff to the line. So people, men, like generally to do that job because, you know, it gives them a lot of freedom to move around. They just like driving something, you know. And so women generally didn't care about it, but a lot of men did. So it was kind of a sought after job. And if one opened up, there would be a lot of people applying. I got the job once because they liked me. No other reason. I lost it quickly when I knocked the fire plug off the wall and the supervisor was coming down and I lost it. And I was going too close to the wall because he was coming down. I didn't want I didn't want to hit him. I didn't hit him, but I did hit the water thing in case the fire broke out. What's it called? Oh, well, anyway. Plan establishes goals and timetables and does not unduly burden other workers. So the plan will establish a goal that they're going to reach somewhere near racial balance at a future date, and so they have to show each year that they're making progress for that date. And they can be excused from it if, say, they have a layoff and they had to fire people. Well, who do they fire? They fire the most recent hires. And if they've been hiring people, blacks, to work on the assembly line, then they have a layoff. They lay off a lot of blacks, and they're not making any progress. They're actually going backwards. Well, they can go in and say, well, there's just not that kind of demand for our products right now. There's a slump, okay, and that's why. And that will give them an excuse. So they can go to the court and explain why they don't meet their goals. But the goals are there, and timetables are set out. Not available in cases of age or disability cases. As a matter of fact, it was mostly in jobs relating to blacks and relating to gender discrimination that you saw affirmative action programs. I don't know that there was any involved with, I don't know of any, I never heard of any involved with ethnicity, but I guess you could have that, or religion either. But certainly you can't have it at age and disability. These are from different statutes, and you don't have that removing the barriers. So if you look at the goal of Title VII, it says to remove barriers. You don't have that kind of language. Instead, with old age discrimination, is that people not be discriminated and that they be treated according to their abilities. So that has nothing to do with some sort of imbalance in the workforce, and there's nothing you can do about that if there is that. You have to show that the person was denied the job because he didn't have the ability for the job, basically, or the person you gave it to was better qualified. So you didn't have affirmative action in age or disability cases. So there's a different statute with different goals. SFFA, Students for a Fair Admissions, Students for Fair Admissions, a group who sought to make Harvard more accessible for Asian Americans. So Students for this Students for Fair Admissions versus Harvard was decided by the District Court October 1st, 2019. Judge Burroughs rejected the claims, ruled Harvard's admissions policy meets constitutional requirements, do not discriminate against Asian Americans. Currently on appeal to the Federal Circuit Court, expected to be appealed to Supreme Court. Harvard justifies it on its discrimination, so-called discrimination, that diversifying student body but not by quotas. So they're diversifying the student body but not by quotas. Quotas have been out for a long time. Second, race is only one factor, and there are lots of other factors. Thirdly, Asians admissions are at 21%. Asian Americans as a group nationally are around 6% of the U.S. population. So they're saying, well, we don't think we're discriminating. Yeah, we're not admitting them under affirmative action, but we don't think we're discriminating doing that. Anyway, so the Asian Americans, on the other hand, are claiming that they have some very good students that are being turned down. I'm sure there's lots of very good students being turned down. Not that that's an excuse if they're actually discriminating. But what they're saying in Harvard, that they take each individual case one at a time, that each person is being judged by his merit, other than the persons that they're taking under affirmative action, which they're not taking Asian Americans under that. They don't need to, they feel. And I can understand, so it'd be interesting to see how that comes out. The Age Discrimination and Employment Act protects workers over 40. Stereotypes about age and ability are prohibited. That's what I mean. It's not about some sort of discrimination going on based on numbers. Prima facie does not require that a worker under 40 fill the job. In other discrimination case, you need to have a worker under 40 filling the job. Unflattering remarks about aging may provide an inference of discriminatory animus. So that's the Age Discrimination and Employment Act. And so a person's going to be judged by his ability. If he can do the job, then he shouldn't be discriminated against. But he should be considered by his record, what his experience is, and what his abilities are. the Americans with Disability Act. This act protects otherwise qualified individuals from discrimination solely because of their disability. Disability is defined broadly. The employer may be expected to make reasonable accommodations, but if a person can't do the job, even with reasonable accommodation, then he has no right to claim the job. He's not going to be hired if he can't do the work. So we have blind programmers here at our university at Ball State, and the blind programmers do the job, and they're very good at it. You know, they have programs to do it, but they can do the work just as good or better than maybe some of the other workers there, I'm told. And so there's no problem with that. Disability is defined as a condition or impairment that, 1, substantially limits a major life activity, 2, a record of such impairment, or 3, being perceived as having such an impairment. If the impairment is correctable, then it isn't a disability. For example, diabetes, people can take medicine for it, right? And people, nearsightedness, I was nearsighted for years, nobody told me I was disabled. You know, nearsightedness is very common, but you can get glasses and that corrects your vision for any work that you need to do. Includes reformed alcoholics. You know, disability does include reformed alcoholics. You know, that there are people who have a medical condition that is, if they take a drink, they oftentimes can't stop, and we know this now to be a chemical condition of their body, not based on their past drinking, but it's just something that people seem to be born with because it goes down through generations, oftentimes skipping a generation, as one generation will see how it ruined his father's life and therefore won't. So I had a cousin like that. His father had seen his grandfather actually, ruin his life, and then they just stopped. So it tends to skip generations sometimes, as children learn not to do that. So morbid obesity, which is of course a condition some people just overeat, and apparently that also may have some physical causes of why certain people are prone to overeat. Untreatable diabetics, but not so diabetics are disabled if it's an untreatable one where you can't correct it with drugs, but not work inhibiting carpal tunnel syndrome, which is thought to be something that can be fixed. So that's not a disability. Defenses, business necessity, which is oftentimes a defense in lots of kinds of these cases. We'll continue with this next time, because I think it's going to take a little too long to go, and we just don't have that much time. But thank you for coming today. I hope you enjoyed these. I always enjoy this lecture, talking about sexual harassment. not that way, but it's just a subject I know well because I actually wrote an article in law school when I was there that was published, and so I had some great success in that. And it was at a time when very few people. I mean, when I started writing, my friends said to me, "You're writing on what?" And they were worried that the floodgates would be too much, that too many people would be suing, that they would be persecuted. I said, look, you just have to remember, you ought to treat women just like you would if it was your mother or your sister there, and don't take liberties with a girl that you don't really know all that well, and don't assume things, and treat them respectfully, and don't think it's just a joke, which I think oftentimes when you see these cases, a lot of times the defendant will claim he was just joking. That was the defense of the salesman. He was just joking around. She laughed too. And there's like a movie that shows that, where a guy goes into a building and this woman is standing there doing some work, moving these newspapers, and he slaps her on the butt. She jumps up and starts wagging her finger at her, and she's very upset, obviously, with it. But also she seems to be laughing, and he's smiling and laughing. Yeah, that was the attitude. This was the movie, and he was the hero of the movie. He was the great man in the movie, and this is how they portrayed him. So I think that young men were actually encouraged to do the wrong things by such movies, by such portrayals of these kind of matters. And so our culture was kind of toxic that way. Well, and that was the only kind of toxicity in our culture. And it's really not totally been eliminated yet, has it? So anyway, thank you very much.